Welcome to this explainer. Today, we're diving headfirst into the high-stakes, incredibly complex legal battle surrounding workplace retaliation. We're going to use real-world court cases straight from our legal source material to uncover exactly how the rules of the modern workplace operate. Whether you're an employee trying to figure out your rights or a manager trying to build a healthy team, the legal drama we're about to unpack is absolutely essential knowledge.
Right. Let's quickly check our agenda for today. We're going to define illegal workplace retaliation, look at when the law protects employees, and then flip the script to see when employers win in court. After that, we'll break down the high cost of litigation and finally wrap up with exactly how you can protect yourself.
Okay, Section 1, defining illegal workplace retaliation. To really understand these complex legal battles, we first have to set the rules of the game. What exactly separates a tough day at the office from a literal federal lawsuit?
Well, the U.S. Department of Labor has some seriously strict parameters. It isn't just about feeling wronged. There are highly specific legal thresholds that must be met before you can even step foot in a courtroom.
So, the absolutely crucial point here is that retaliation requires two interconnected elements. First, you have to engage in what the law calls a protected activity, so something like filing an EEOC discrimination claim or reporting a safety violation to OSHA. Second, that protected activity has to be directly followed by a materially adverse action from your employer. You literally need both to even have a case.
And this is where it gets super interesting, because adverse actions aren't just limited to getting fired. Sure, termination and demotion are the obvious ones, but the courts also recognize sudden shift reassignments, targeted intimidation, and harassment as retaliatory. If an employer makes your day-to-day work life materially worse specifically because you spoke up, well, that crosses the legal line.
Section 2, when the law protects employees. Let's move into our first set of case studies and see how this actually plays out when employees take their bosses to court. We're looking at two landmark Supreme Court decisions.
In our first Supreme Court showdown, Thompson versus North American Stainless, we have a really fascinating situation. A man is fired shortly after his fiancée, who works at the exact same company, filed a gender discrimination complaint. So the employee claimed third-party retaliation, but the employer's defense? They argued that because the man himself didn't file the charge, Title VII's anti-retaliation provisions didn't technically protect him.
What's really brilliant here is the specific standard the Supreme Court applied to figure this all out. They asked, if you were an objective person, would seeing your partner get fired stop you from speaking up about discrimination?
And the court said, absolutely yes, it would. They ruled entirely in favor of the employee, essentially stating that firing a close family member or fiancé would clearly dissuade a reasonable worker from making a complaint. This was a massive win for workers, officially establishing that third-party retaliation is a direct violation of federal civil rights laws.
Next up, we have Burlington Northern and Santa Fe Railway Company versus White. Here, a railroad worker filed a discrimination claim and was subsequently reassigned to a physically harder, way less desirable job and then suspended for 37 days without pay. The employer's defense was basically, no harm, no foul. They pointed out that they eventually reinstated her and gave her back pay, arguing that because the financial harm wasn't permanent, it shouldn't count as unlawful retaliation.
So we really have to ask, did the employer actually break the law? Even though she eventually got her job and her money back, we have to look at whether that grueling 37-day suspension crosses the legal threshold of a materially adverse action.
Once again, using that same objective person standard, the Supreme Court ruled in favor of the employee. The justices determined that enduring over a month without a paycheck, even if you're reimbursed later, would terrify almost anyone out of whistleblowing. The temporary nature of the suspension absolutely did not excuse the retaliatory behavior.
Section 3. When employers win in court. Now, litigation is never a guaranteed win for the employee. It's a two-way street. So let's look at a major plot twist from our source material, affirmative defenses, which is when employers successfully prove they acted well within their rights.
Consider the case of Bragg versus Munster Medical Research Foundation. An employee claimed retaliation after being denied a full-time position and transferred to a facility with less pay. But look at the employer's rock-solid process here. They didn't just deny the claim, they brought receipts. Step 1, they had heavily documented her substandard work and progress reports. Step 2, they had records of multiple feedback meetings with her. And Step 3, they executed the reassignment based purely on that documented performance.
Because the employer meticulously followed those steps, the court ruled entirely in their favor. The key takeaway for us here is that engaging in a protected activity, like filing a complaint, does not act as some magic shield that excuses you from doing your job well. If an employer has a legitimate, non-discriminatory reason for an adverse action, they're going to win in court.
In our final case study, Hutchinson versus City of Oklahoma City, a female water treatment worker called an ethics hotline to report her supervisor for improperly scheduling himself for overtime. She later sued, claiming a hostile work environment and retaliation. But the employer's defense was simple and completely devastating to her case. They pointed out that absolutely no adverse employment action ever occurred. She wasn't fired, her pay wasn't cut, and she wasn't demoted.
The court swiftly sided with the employer. Why? Because the employee failed to provide evidence of any material harm. You can't win a retaliation case just because the workplace feels tense after a complaint. You have to be able to prove a tangible, adverse employment action actually took place.
Moving on to Section 4, the high cost of litigation. Look, these legal dramas are thrilling to analyze from the outside, but actually living through them is an entirely different story. Before anyone rushes off to the courthouse, we really need to talk about the real-world toll these battles take.
As our source bluntly points out, stepping into a courtroom is an intensely adversarial and high-stakes gamble. It is a grueling process, and ignorance of how the system works is literally the fastest way to lose everything.
Employees have to weigh their rights against some massive realities. Legal proceedings drag on for years. They are incredibly stressful and they drain your finances. Plus, even if you win, back pay and getting your old job back are never a sure thing. Add to this the fact that most workers are in at-will employment situations, meaning you can technically be fired for almost any non-discriminatory reason, and you begin to see the severe power imbalance at play here. Which brings us to Section 5, how to protect yourself. Considering all these massive risks and the strict legal thresholds we've discussed, how do you practically navigate and survive the modern workplace? Thankfully, our source material gives us some clear recommendations for both sides of the aisle. Let's start with the employee playbook. Your absolute best defense is proactive record keeping. Keep a digital folder or a private work journal documenting your performance and any incidents. The source also notes that organizing or forming a union provides a level of collective protection and solidarity that you just don't get on your own. But most importantly, follow your company's reporting policies exactly as written. And always remember, filing a complaint doesn't mean you can stop doing your job properly. Now, for the managers tuning in, here's your playbook. Just like the employees, you've got to document everything, both the achievements of your team and any conflicts or performance drops. You are the facilitators of the workplace culture. Encouraging open dialogue without fear of punishment stops lawsuits before they even start. You must train your personnel on what retaliation actually is, and crucially, as the EEOC warns, you have to actively suppress your own natural personal feelings of revenge when an employee criticizes you or files a complaint. Before we wrap up this explainer, I want to leave you with this vital question regarding your own career readiness. If workplace retaliation happened to you tomorrow, are your personal records robust enough to prove your case to an objective person? Whether you are an employer or an employee, documentation and knowledge are your very best forms of protection. Thank you so much for joining me to unpack these fascinating legal cases, and I really hope this helps you navigate your professional life with just a bit more clarity and confidence.